now we are going to cover the US legal system. We're going to do a review of the US legal system. These are the materials that would have been posted earlier this semester. We had also looked at the UK legal system. We won't be looking at that today. If you have any questions regarding the UK legal system, as usual, please post them on Virtual Classroom. As far as the US legal system is concerned, I wanted to do a review because I will be posting quizzes on June 3rd. Quiz Leap 1 Preliminaries is the first graded quiz of the semester, and it will cover the US legal system, the UK legal system, paralegals, and document management. Please read the LEAP assessment note in the general announcement section on eMentor to get more information about the topics covered in Quiz 1. Let's get started with the US legal system. I'm going to briefly just talk about the sources of law. There are two types of sources of law, two broad categories, that is. The first one is primary, the second is secondary. Primary sources of law are sources of law that are promulgated by official bodies with the authority to make law. Therefore, we have under primary sources of law either binding or persuasive. A primary source of law is binding if it is within the same jurisdiction and it comes from a higher authority within that jurisdiction. A primary persuasive source of law is that source of law which may come from a different jurisdiction or from a lower authority within the same jurisdiction. It will still be primary, however, it could be persuasive. Secondary sources of law, on the other hand, are never binding. They are always persuasive. An example of a primary binding source of law is the United States Constitution, in the United States, that is. That source of law is binding across the states at every level. The United States Constitution is a supreme law of the land. Nothing takes precedence of the US Constitution. We also have 50 states in the United States, and each of those states has its own state constitution. State constitutions are primary binding authority within that state. Outside of that state, however, they will most likely be primary persuasive authority. Other states may look at that state constitution and say, well, I am going to choose to be guided by that other state's constitution. They don't have to be, however. Federal statutes, another source of primary binding authority. State statutes, again, primary binding within that state. Case law may be binding or persuasive, is always primary, however. It's made by an authority and a body that has the authority to make law, by a judicial body rather. We also have federal and state administrative regulations and decisions. Again, primary binding, maybe primary persuasive if they're state administrative regulations and decisions. The only primary binding authority that is binding on all other primary authorities is the US Constitution. It is binding over state constitutions, over federal state statutes, over case law, over federal and state administrative regulations and decisions. All others may be binding or persuasive on other primary sources of law. Secondary, as I said, are only persuasive. We have legal encyclopedias, treatises, law reviews and journals, and nutshells. You can take a look at what each of these is in the materials on eMentor on US legal system. To be brief, however, all of these are an interpretation, a commentary on the law. They are not the law. They may be written by law professors, by lawyers. They are not promulgated by a body that has the authority to make law. They're not made by the legislature or the judiciary. Therefore, they are not primary. And therefore, they are not binding. They are only persuasive. The next idea is the concept of stare decisis. Full word, the full phrase is stare decisis et non quieta movere, a Latin phrase, which means to stand by decisions and do not move that which is still. All common law courts follow stare decisis. India and the United States follow the common law legal system, as does the United Kingdom. Stare decisis refers to the precedential value of courts. Precedent is when a legal case establishes a legal principle or a rule that subsequent courts and subsequent decisions must follow. Stare decisis particularly says that prior court decisions must be recognized as precedent. They must be followed as long as the hierarchy, the jurisdiction, and the facts are in order. Therefore, courts in subsequent cases must follow the decisions of prior cases if the subsequent court is a lower court within the same jurisdiction, and if the facts are indistinguishable from the facts in the case that set the precedent. In the United States, we have a federal judicial system and a state judicial system. The federal judicial structure, you have district courts at the lowest level, you have courts of appeal, which are circuit courts at the middle level, and you have the US Supreme Court. Now, the US Supreme Court, which is at the top of the federal judicial structure, operates under a system of discretionary review. So, US Supreme Court is not obligated to hear appeals. However, it may grant certiorari upon the filing of a writ of certiorari from the Court of Appeals. If the Supreme Court grants certiorari, it means that the court has agreed to hear that case, to hear that appeal. However, the Supreme Court is not obligated to do so. The courts of appeal, the circuit courts that is, have a system of mandatory review. They must review all appeals from the district courts. They must hear all cases that are appealed up from the district court. They are obligated to do so. They do not have a choice whether or not to appeal. However, most matters on appeal, they look at the law and not the facts. New factual evidence often cannot and mostly cannot be added at the appeal stage. The court only looks at the law, the decision based on law that was made. There are 94 district courts in the United States spread across the country. There are 13 circuit courts, again spread across the country. These are the federal judicial boundaries. As you can see, there are 11 circuit courts shown on this map. The 12th one, along with these 11, is geographically defined. The 12th one is in Washington, D.C., covers D.C. area. If you can see on the right side, there are initials for states. D.C. is towards the bottom of the map. That is where the federal court for the D.C. circuit sits. The 13th Circuit Court is the Federal Court of Appeals for the Federal Circuit. That hears appeals on specific subject matter. It's not geographically defined. The state judicial structure, on the other hand, consists of the trial county courts at the lowest level. Above that is the appellate courts, and in most instances above that is the apex or the highest court of the state. Most states, there is an apex court. However, in a few states, such as Maryland and New York, the highest state court is the appellate court. There is no review possible above the appellate court. In fact, there is a lower court in New York that is known as the Supreme Court. However, the structure remains the same. Trial courts above, which are the appellate courts. And then most states have an apex court. Again, even in these appellate courts, the court looks at matters of law, not matters of fact. The decision that the appellate court makes is based on law, not on facts. As far as jurisdiction is concerned, most and every dispute can be filed before a state court unless specifically prohibited by law. That's referred to as state court jurisdiction. The state court has jurisdiction to hear any and every dispute unless specifically prohibited by the law. Alternatively, federal courts have jurisdiction in very few cases. There are few bases of jurisdiction, 5 in particular. They are a situation in which the United States is the plaintiff or the defendant in the case. That means the United States government is the plaintiff or defendant in a case. Second base of federal jurisdiction is if the complaint is based on a federal jurisdiction question, meaning that it calls into question a matter of federal law. For instance, it calls into question the United States Constitution or a federal statute. The third base of federal jurisdiction may be cases that fall into areas such as admiralty and maritime, specific subject matter areas, in other words. The fourth base of jurisdiction for federal courts would arise in diversity cases. Cases in which the plaintiff and the defendant come from different states and the disputed amount, the amount sought to be recovered, is exceeding $75,000. The last base of federal jurisdiction is involved in alienage cases, in which one of the parties is a United States citizen and the other is a foreign national, not a resident of the United States. Here also the amount to be recovered, sought to be recovered, must exceed $75,000. Again, to confirm and clarify, these are the only situations in which a federal court would have jurisdiction. As noted in the previous slide, a state court has jurisdiction in all matters unless specifically prohibited by the law. Therefore, these are the situations in which the law specifically prohibits a state court from hearing a case. These situations, a federal court must hear the case. Removal jurisdiction is another situation in which a federal court would have jurisdiction. That is when a case is brought in state court but is removed to federal court because the federal court has jurisdiction. We're going to specifically spend some time on diversity jurisdiction. As we saw on the last slide, diversity cases involve a plaintiff and defendant from different states with an amount in controversy, an amount that's sought to be required in excess of $75,000. The reason for diversity jurisdiction was that the framers of the United States Constitution were worried that out-of-state parties would not get a fair hearing in a state court, that the state court would be prejudicial against out-of-state parties, that the state court would be biased towards residents of that state. Therefore, framers of the US Constitution felt it best that if parties are from two different states, they be able to bring the case in federal court and not be left to the bias of any state court. There must be complete diversity between the plaintiffs and from all the defendants in the suit. However, all the plaintiffs can be from the same state and all the defendants can be from the same but different state from that of the plaintiffs. Plaintiffs and defendants must be from different states than each other. I'm going to look at a few questions and go through them along with the answers for some practice. Smith from California sues Jones from California in a federal district court in Illinois. As you can see, there are two states involved here. However, Smith is the plaintiff from California and Jones is the defendant, also from California. There is no diversity present here, and they are bringing the case in a federal district court in Illinois. There is no diversity. The plaintiff and the defendant are from the same state of California. Therefore, even without looking at whether the amount sought to be recovered exceeds $75,000, we know that these situation will not fit into a diversity case. Second example, Reed from Oregon sues Smith, California, and Jones, California. In this situation, Reed, the plaintiff, is from Oregon, while the defendants, Smith and Jones, are both from California. As I mentioned before, as long as the plaintiff is from a different state than the defendants, we have diversity. The defendants can be from the same state as each other, which is the case here. Let's look at the answers for these two questions. As I mentioned, the parties are both from California. No diversity between them in the first situation. It doesn't matter that they sued in Illinois. It doesn't matter where they bring the suit as long as they meet diversity. The second situation, yes, it's a proper diversity case. Parties on the same side, that is plaintiffs, may be co-citizens of the same state. However, parties on different sides must be from different states. The last practice question involves Reed from Oregon and McGee from New York and Rowe from Massachusetts suing Jones from California, Smith from California, and Tyson from New York. Here we have plaintiffs from Oregon, New York, and Massachusetts suing defendants from California and Tyson. Therefore, one of the plaintiffs, namely McGee, is from the same state as one of the defendants, namely Tyson. Therefore, there is no diversity. There is someone from the same state on both sides of the case. Some part of the case will have to be heard in state court. However, two of the defendants could still be sued in federal court. Therefore, the case would be separated. Part of it would be in state court and part of it would be in federal court. Now, these situations that we looked at, we're looking at only the resident states of the parties. We were not looking at the amount in controversy. So first step is to look at where the plaintiff and defendant are from, and to then look at whether the amount that the plaintiff is seeking to recover exceeds $75,000, which is what we'll do in our next step. Let's look at a few more questions, however. We have Smith from California suing Jones from California in federal court in California under a federal firearms statute. Can the court hear the case? Although there is no diversity, we do not need diversity for the federal court to have jurisdiction, because one of our bases for federal court jurisdiction is that the complaint brings into question a matter of law, which here is the federal firearms statute, a federal law. Therefore, the federal court would have jurisdiction. Our second situation, our example here, Smith from California sues Tyson from Massachusetts for breach of contract, over which there is concurrent jurisdiction in state court. Can Smith do this? Let's look at the first two answers. Yes, they have a question arising under federal law that's a separate basis for federal jurisdiction. Diversity is not required. The second situation, just because the case can be brought in federal court doesn't mean it has to be brought in federal court. Any matter can be brought in state court. Plaintiffs are free to choose where they want to bring the case, even if the federal court has jurisdiction. State courts, therefore, have concurrent jurisdiction over cases that federal courts could hear unless Congress makes federal jurisdiction exclusive, unless the law forbids state court jurisdiction. Therefore, since the state has concurrent jurisdiction, Smith can sue in federal court or in state court. Our last situation, Smith from California sues McGee from New York for libel in federal court. He then learns that Jones from California was the author of the article at issue. He wants to add Jones as a defendant. Can he still proceed in federal court? As you can see, the plaintiff and the defendant are from different states. Therefore, yes, there would be diversity. However, Smith from California then wants to add Jones from California as a defendant. Can he still proceed in federal court after adding the second defendant? Here, of course, that would destroy diversity. The federal court would be forced to dismiss the case because the second defendant would have destroyed diversity. The second defendant is from the same state as the plaintiff. However, the plaintiff here can choose to sue in one state, one defendant, and sue the other one in federal court, or he can dismiss the federal case completely and sue both defendants in state court. He has a choice. The plaintiff has a choice where to bring the case, whether to bring one in one court and another in another court, or to make his life possibly simpler and bring both defendants in the same court, which would have to be state court. As I suggested to you, the last few examples we only looked at whether the plaintiff and defendant had complete diversity, whether they were from different states. If in fact we are able to say that the plaintiff and defendant have complete diversity between them, we can go on to the next step, which would look at whether the plaintiff is seeking an amount in recovery that is greater than $75,000. The amount recovered is also referred to as the amount in controversy, the amount in dispute, in other words. A plaintiff's good faith claim for $75,000 will control unless the court can find to a legal certainty that there is no way that the plaintiff can recover that amount, that there is no way that the plaintiff's recovery will reach $75,000. However, the court must find this to a legal certainty, and if they do not find this to a legal certainty, then the case will continue. The amount of controversy, the amount in recovery that the plaintiff has stated will stand unless the court can find to a legal certainty that that amount cannot be recovered by the plaintiff. It is necessary that the court find this to a legal certainty in order to destroy diversity jurisdiction. Otherwise, diversity stands. A few other issues involving the amount in controversy. A plaintiff may add up all his claims against one defendant to reach $75,000. However, a plaintiff cannot add up all the claims against a number of defendants to reach $75,000. What this means is, if there are more than one defendant in a case, the plaintiff cannot add up all the claims against all those defendants to reach $75,000. However, in a case where there is one defendant, a plaintiff can add up all his various claims from different situations or involving different topics in law to reach $75,000. In addition, plaintiffs cannot join together with other plaintiffs and add all their claims to reach $75,000. More than one plaintiff in a case, they cannot add up their claims against one defendant or against many defendants to reach $75,000 amount in controversy. Therefore, conclusion of course is that each plaintiff must have a claim for more than $75,000 against each defendant. Since we cannot add up, each plaintiff must have a claim exceeding $75,000 against each defendant if there is in fact more than one defendant. Amount in controversy. Let's look at a few questions. We have A sues B for $40,000 for personal injuries, and A sues B for $40,000 for damages to A's car from the same incident. Can we proceed? The second question. A sues B for $35,000 on a loan and for $40,000 on an unrelated breach of contract. Can we proceed in that situation? The last case that we have is A sues B for $40,000 for damages in a car accident. C also sues B for $40,000 for damages arising out of the same accident. It's important to look at in each of these situations who is the plaintiff, who is the defendant. Are there more than one plaintiff or more than one defendant? The first situation, we have one plaintiff suing one defendant for a variety of claims. Therefore, can we add it up? Let's take a look. Yes, there's one plaintiff can add up all his claims against one defendant. Therefore, the two claims add up to more than $75,000. The amount in controversy is met. The second situation, A is one plaintiff suing another defendant for $35,000 on a loan for $40,000 on an unrelated breach of contract. Again, A can add up all his claims against one defendant, even if they are totally unrelated. Amount in controversy is met. The last example, A sues B for $40,000 for damages in a car accident. C also sues B for $40,000 for damages arising out of the same accident. Important to note here, we have two plaintiffs, A and C, both suing the same defendant, B. Can we add those up? Can two plaintiffs add up all their claims against one defendant? As you see, both claims will be dismissed because individually they fail to meet the amount in controversy requirement. Plaintiffs cannot add up their claims against defendants. They must separately meet the amount in controversy requirement. Claims of different plaintiffs cannot be aggregated. I'd like to take a few minutes to just mention a recent development in the United States. As many of you may be aware, earlier this year, President Obama became President of the United States. Under the US system, the President of the United States may appoint Supreme Court judges. There are 9 Supreme Court judges in the United States, along with the Chief Justice. The Chief Justice is Roberts currently, Justice Roberts. At this point, there have been only a very few number of women on the bench. It was only yesterday that President Obama appointed another woman, Judge Sotomayor, to the US Supreme Court bench. Appointing a US Supreme Court judge is often a political decision, seeing as the president is a politician. Therefore, if the president is able to appoint a judge when he is in power, he will usually appoint someone with political beliefs similar to his. In this situation, Judge Sotomayor was a federal appeals judge. In addition, she is also the first Hispanic woman and the first Hispanic to be a judge on the US Supreme Court. This is a historic moment, as you may all know, because President Obama is the first black president of the United States, and he has appointed the first Hispanic woman to be a judge on the US Supreme Court. Many are concerned about her decisions that she's made in the past. One situation that has come in the news is that abortion backers are concerned about her appointment because of her views in previous decisions. Going forward for LEAP, I would like people to keep up with her appointment and her decisions in the US Supreme Court. The US Supreme Court is a very powerful body in the United States. Some of the decisions that they have made have changed the face of the United States. Not only the legal system, but of course the way people live their life. An important case to be mentioned is Loving versus Virginia, which finally said it was unconstitutional to prevent people of African American descent from marrying people of white descent. It allowed interracial marriage. It said preventing interracial marriage was unconstitutional. The case is again called Loving versus Virginia. It would be interesting for you to keep up as PGD-LPO students with Supreme Court cases, with decisions going forward by the Supreme Court, especially on constitutional law matters. Thank you.